My dear friend, once again you are welcome to our channel. Today in series of Doctrine of Constitutional Interpretation, our next doctrine is Doctrine of Occupied Field. In earlier topic we have covered Doctrine of Implied Field and we will be covering all Doctrine of Constitutional Interpretation one by one. So let us see in this doctrine what we are going to cover. You can see screen, there are two topics we have chosen to cover it to understand what is doctrine of occupied field and what are related leading case laws related to this doctrine. Basically, as the name suggests, occupied field means the field which is already occupied, or in other words, who has power to occupy a field. If it is already occupied, who can control it? As you are aware that in Constitution of India, primarily there are two legislative bodies those can enact law. One is central government or parliament, other is state legislation. As per Schedule 7 of the Constitution, there are three lists. List 1 is for parliament, list 2 is for states, and list 3 is concurrent list. And this is done to have clarity on the power that parliament or states can choose and make law topic as per division in the different list. However, Article 254 of our constitution lays provision in case there is one topic and by the way both parliament and states make law on them on that topic, in such situation what will happen, and this is covered under doctrine of occupied field. This doctrine says when on any field, any topic, central government or parliament is competent to make law, or it is any entry in the concurrent list and central government has made law on that, and on the same topic state government has also enacted law. The doctrine says that law made by central government will prevail and will be valid against the law made by state, and the law or act enacted by state government shall be held invalid to the extent it is in contradiction with the law made by center on that topic. I hope you will get clarity on this. In simple language, let us understand, if on same topic both state and central government made law, and if central government is competent to make law on this by virtue of list 1 or concurrent list, the law made by central government will be valid. However, there is one proviso to this. If any state government has made law and that law has been sent to president for his consent and president has given his assent already to it, in that situation that law will prevail. However, there is one more control provided to this second part, Article 254(2). Provisos say even the center government has power at any point of time later, parliament can amend such law, or bearing or repealing power they have to such law which was valid because of it is assented by the president. So in overall, if you see, if there is any common topic and both legislation of state and parliament has made law, ultimately the more power is with parliament. I'm sure with this explanation you get clarity on this, And for a law student, it is always to quote leading question to make a better answer. We will be covering two leading case law related to this doctrine. First one is State of Kerala versus Mar Apperam Kuri Company Limited AIR 2012. In this case, uh, Kerala Chitti Fund Act made by Kerala state government and Chit Fund Act made by Parliament was in question and was in contradiction to each other. Supreme Court held that the Chit Fund Act made by Kerala state will be held invalid and Chit Fund Act made by Parliament will be held valid under the interpretation of Doctrine of Occupied Field. Second leading case law on this topic is Rajeev Sarin versus State of Uttarakhand AIR 2011. Under this case, Supreme Court held that under Article 254 of the Constitution, if a state law passed in respect of concurrent list upon which union law is also present, in such case, state law would be invalid to the extent it is contradicting to that center's made law. In nutshell, let us summarize in that way. Again, if on same topic both parliament and state legislation had made law, ultimately parliament has higher power and the law made by parliament will be valid under the doctrine of occupied field. So we have discussed both this topic, and by this explanation, I'm sure you get better clarity on this doctrine. Thank you very much for watching this video till end. If you have further any question, please mark in comment box. I will be happy to reply. Please like and subscribe to the channel and share this video to your friends to get benefit at the end. Thank you very much again.